Hi everyone, welcome to today's webinar on how to write a will and include a charity. Today's webinar will be presented by Lisa Ziegler, who is the Fundraising Manager for MDFA, and Nicole Platt from Griffin Legal. Before we begin, we'd like to acknowledge the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders, past and present, and extend that respect to all Aboriginal and Torres Strait Islander peoples today. So just a little bit of housekeeping before we jump into the webinar. So if you have any IT issues, please try refresh your page. If not, you can call our toll-free national helpline number on 1800 111 709. I must note that all microphones and videos are switched off for all attendees, so we won't be able to hear you or see you. You will, however, still be able to communicate with us and ask questions using the chat box, which you'll find on the right-hand side of your screen. I'm now showing a screenshot of where you can find this feature. First, you will click on this icon, and that should open up this white box where you can type your question in and then press send. I must note that we will be answering all questions at the end of the presentation, and please try to keep the questions as general as possible as we can't provide any personal support over the webinar. You may notice a few other icons along the dark grey bar, the first being these 4 arrows that are facing outwards. Clicking on that will allow you to expand the view of your webinar to full screen. And lastly, we have the exit button. So clicking on that will allow you to exit the webinar. So now I'll pass back to Lisa.
Good morning, everyone. Welcome and thank you so much for taking the time today to join Nicole and I. Today's webinar will consider all the legalities of drafting a will. And while many people prefer not to think about estate planning, it doesn't have to be as complicated as dreaded a process at all. Because every person's situation is different and laws vary depending on where you live, the advice provided will be general in nature. We're not able to provide personal advice over this webinar. So let me introduce you to the lovely Nicole Platt. Nicole is a partner at Griffin Legal and specialises in estate planning and administration. Nicole has been specialising in estate planning for about 6 years and has been the partner in charge of estate planning team at Griffin Legal for the last 3 years. She has worked in both private and public sectors for the last 20 years as both a lawyer and a qualified accountant. So without further ado, let me hand over to Nicole, who will talk you through all there is to know about estate planning.
Thanks, Lisa. I'm delighted to be here with you all today. Whilst I can't see you, you can see me, but I'm here to talk about my favourite topic, and that's wills and estate planning. It's something I can talk about all day, so hopefully you guys get a little bit out of it today. Just up on your screen there is a list of things that we're going to be covering off today. So we're going to run through what is a bequest, what is a will, estate versus non-estate assets, what makes a will legally binding, the different forms of gifts that you can leave in a will, how you go about protecting your estate, and then hopefully at the end we'll have some time if anyone's got any questions to run through some things then. So we'll get straight into it. So what is a bequest? Now that's really what we're here to talk about it today. So specifically, a bequest is a sum of money or an asset that is given to a community organisation upon the owner's death as specified in the owner's will. Now, bequests can be given freely, which means the organisations can choose what they do with the money in any way it sees fit, or it can be given with conditions. So those conditions must be honoured, and a failure to honour the terms of a bequest could result in legal action being taken against an organisation who doesn't adhere to those specific requests. This is why many organisations have specific wording that they recommend that you use when you're drafting a will. So quite often they'll have a guide for what you should insert should you want to leave a bequest to a particular charity or organisation. Now, an endowment differs slightly to a bequest in that it's normally a fund or an amount of money which is established to provide an ongoing income for beneficiaries, which can include community organisations, and that can be used for the benefit of a sole organisation or can be used for a number of beneficiaries that could benefit from that fund. Next slide. So this is some things to consider when you're thinking about making a bequest in your will. I'll touch on a few of these things as we go through today's session. when making your will, you're really determining how you want your assets to be distributed upon your death. And in doing so, these are some of the things that you should think about when considering if you'd like to make a bequest, and if so, how much do you want to leave out of your total asset pool as part of your will. Just here on a side note, I just want to make a comment about funeral arrangements. Many people include details of their funeral arrangements in their will. As a will drafter, I do this all the time for people, but I have to remind people that often a will isn't found until after funeral arrangements have already been determined. So make sure somebody knows what you want to happen to your body when you die. There's nothing worse than a family member who discovered the deceased wanted to be buried just after they've had them cremated. So don't rely on your will to convey that sort of information to your loved ones. Make sure you have somebody who knows what you want to happen with your body when you die. So that's part of your considerations in addition to the things that are on the slide at the moment. So handling your affairs, funeral arrangements, assets, charities. Those sort of considerations brings us on to the next topic, which brings us to our next slide. What is a will? I'm sure a lot of you understand what wills are, but just to take you through some different things that you may not have been aware. The standard, a will, it's your legal document. It sets out your wishes for what you want to happen to your assets after your death. As noted before, your will can include bequests to a community organisation, and it's all dependent on how you word things on how things will happen. So there are two main types of wills, what we consider a standard will and what we consider a testamentary trust will. A testamentary trust will is a will that establishes a legal relationship where one person, the trustee, holds property for the benefit of another person, which is the beneficiary. These are drafted so that there's a schedule in your will that actually forms the trustee that dictates the terms of the testamentary trust. So testamentary trust is basically very similar to a standard discretionary family trust, but it's a trust that's established only via a will, and that's the only way you can set it up. And if you don't have the provisions in your will to do that, your beneficiaries won't have the option of setting up a testamentary trust after you die. So when deciding whether or not you need a standard will or a testamentary trust, there are certain things that you need to consider. One is simply the size of your estate. If it's a really large estate, a testamentary trust might be, quite important to you to protect your assets, but there are other particular considerations that relate to your beneficiaries that you should consider when deciding what type of will you should have. So some of those things are any of your beneficiaries bankrupt or at risk of becoming bankrupt? Are any of your beneficiaries mentally incapable or drug or alcohol dependent? Any of your beneficiaries in an unstable relationship, or are any of your beneficiaries minors, that is under the age of 18? So if you answered yes to any of those questions, you might want to consider a testamentary trust as to be established in your will rather than just a standard basic will. There are tax benefits to preparing testamentary trust wills, but the major benefit of them really comes about through that asset protection that it provides. So as the assets are not owned by the beneficiaries themselves, there's a level of protection provided by the trust. It also removes an element of control from beneficiaries who may not be able to control or maintain their own finances very well, or who are being influenced by others to dip into their inheritance when you don't want them to. So that's where the real asset protection comes into, protecting for future generations from that perspective. I'll go a little bit more into testamentary trust a little bit later, but for now, as noted on the slide, who needs a will? Everybody. If you are over the age of 18, you should have a will. Even if you think you don't have any assets, you should have a will, and if you know anyone who's over the age of 18 and who doesn't have a will, tell them they should do it now. There are a lot of risks with dying without a will. Certainly, it can create a really complicated situation for your loved ones that you leave behind. Because if you die without a will, you'll be said to die intestate. There's legislation which will then apply to determine the distribution of your estate if that happens. Now, for some people, this isn't a big deal. Their particular family situation actually aligns with how the legislation says your assets must be distributed if you don't have a will. But in other cases, it can have real dire consequences. My favourite case example of this, and I tell this one to everyone, and this is usually the one that has people rushing out to tell their kids and everybody go and get a will done. This is an actual case, a young girl who lived in New South Wales. She was 19 years old. She lives with her mother. She had never met her father. He left when she was a baby, had never had anything to do with her. She didn't own any assets. She just lived at home, as many people do. She headed off to work one day and was in a car accident. Now, that car accident actually resulted because she was at work in quite a substantial financial payout, but because she didn't have a will, she died intestate, and the law said her assets, as she was a single individual living at home, would go to her parents. That money got divided between half for her mother and half for a man she had never met who had nothing to do with her, and her father benefited from her death even though he hadn't provided any support or she'd never even met him. So it's a really key thing. You may have assets that you don't actually think you have when you pass away. I know, lots of my friends, oh, I own nothing but shoes, but there's really other things that you may not be considering, as happened in this actual case, a large insurance payout. So if you're over 18, make sure you have a will. In addition, if you don't have a will, there's also a lot of additional legal procedures that you have to follow in order to administer an estate without a will. So it just creates another level of burden for your loved ones, and it can be an additional expense as well if you don't have that document in place. So move on to the next slide. So dying intestate, who gets what? This slide shows who gets your assets if you die intestate in the ACT. So legislation decides, and each state has its own. So there's slight variations between each state. Sometimes, as this slide sort of says, if you've got kids, the first 200,000 goes to your partner. In other states, it's different values before that kicks in. So it changes depending on where you live. The order of next of kin is as it is on this slide. Then after that, it will consider siblings, grandparents, then aunts and uncles. And then if any of those people have passed away and have kids, then their kids will get a share of the estate. So there's a number of people that you have to sort of go through and tick off before the government steps in and takes a lot. But ultimately, that is the result. If you don't leave a will and you don't have any of these people, government takes your estate. So not having a will or having an out-of-date will can result in the provisions of this slide being applied. And so when I'm preparing a will, I always recommend that you leave a provision in the event that all your beneficiaries predecease you. We call that a whole family tragedy event. It's terrible to think about, but if you're all traveling in the one bus and there's an accident and you all pass away together, you should think about having a backup. And this is quite often where a charity comes into people's considerations for leaving their estate to. It's usually wise to just insert a charity or some other person addition so your estate doesn't end up with the government if something goes terribly wrong. So go to the next slide. This is something a lot of people don't realise. We have estate versus non-estate assets, and your will only deal with what's classified as estate assets. The biggest misconception is a will deals with everything. And this slide gives an example of what is determined to be estate assets and what assets will fall outside of your estate. So things such as assets owned jointly, quite often people own property as joint tenants. That will not form part of your estate. So if you own a house with your spouse or someone else and it's owned jointly and you pass away, the house doesn't form part of your estate. So if it owns jointly, the remaining owner, the house will automatically pass to them. Now this differs to if you own something as tenants in common, where each individual owns a specific share of the property. In that case, if you own a specific share as a tenant in common, your share will form part of your estate. Now, this can cause some problems when drafting wills and people aren't aware of how they own their property. You'd be surprised how many people don't know if they own their property jointly or if they own it as tenants in common. And a lot of lawyers have been tripped up with this as well, not doing their searches. So if you have property, we always recommend doing a title search to confirm how you own it. Because if you think you own a particular share and you leave it to another person and you actually own it as joint and it doesn't form part of your estates, people can make claims on your estate that way and make claims against lawyers too. So it can get quite tricky. Other things are, you'll notice on that slide that we've got superannuation under both estate and non-estate assets. Super is a tricky one. It can depend on whether or not you have a binding death nomination in place. So if your super fund allows you to nominate someone directly to receive your benefits from your superannuation funds, then these assets won't form part of your estate. However, you can also nominate your what we call legal personal representative in your super fund to be your beneficiary, and a lot of people get confused thinking that's going to be their lawyer. It's not. What that means is you are actually leaving your superannuation funds to your estate to be dealt with in accordance with your will. So sometimes super will form part of your estate assets and sometimes it won't, and it really is determined by those documents that you have behind that a lot of people don't realise that they signed when they started a job, they lapse. You need to keep them updated, and you need to be really aware of what's going on with your super and how it's going to be left. Sometimes people use that as a tool to keep assets out of their estate. If you're worried that someone's going to make a claim on your estate, you might actually want to keep that big chunk of asset out of your estate. Usually it's quite substantial for most people's wills. So if you think there's going to be a claim on your estate, you may want to intentionally leave those funds to someone directly so that if a claim is made on your estate, it doesn't form part of the pool of assets that get fought over should a claim be made. Again, this is similar to insurance. If you've nominated someone specifically, it will not form part of your estate assets to be left in accordance with your will. So that's just something to be aware of when you are drafting your will, issues that can arise with how you actually own your assets, what assets are actually going to be covered by your will, because not everything is. And so you really need to know what you're doing if you've got quite a complicated asset structure, what's in and what's out. Head to the next one. Okay, what makes a will legally binding? There are some really specific things that have to be addressed in order for a will to be considered a binding document. There are four main categories, which I'll go through now. The first is that a person making the will must have capacity. And this means that the person must be over the age of 18. They have to be of sound mind, memory, and understanding. When I meet with someone to prepare and execute a will, I have to be satisfied of their capacity, that they understand what they're doing, they understand that the result that might happen if they sign the document, and that they're able to execute that document. If I'm not satisfied that someone understands what they're doing, I cannot sit and sign a will with them. There has to be, the second main thing is that there has to be an intention to create a binding document. So the person executing the document has to have the intention to make a will. So they have to actually have that intention that they want this to be a binding document on something, not just that they've sort of been sitting there at the pub and going, oh, I'll leave you my car, mate. That is not showing intention to actually create a binding document. They have to show intention if they want to alter their will or revoke a will, whatever the case may be when they're dealing with their estate planning. You know, a comment sort of made off in jest, offhanded, can be held to be legally binding. And there have been cases people try to make claims on estates just because they're sitting with their mate and he says, oh, I was going to leave you this. But this intention is where this sort of comes in to say whether or not that's going to be effective and upheld, and whether it's going to create an enforceable binding will. The third thing that has to be present is knowledge and approval of the contents of the will. So this is quite common now where kids are helping their parents make wills. They contact the lawyers to say, hey, mum and dad need a will, I need to give them instructions. But the person who is creating the will, the testator, must be aware of and approve any inclusions in the will. So it's become very common now, and this is where the whole situation of elder abuse is arising, where people are making wills on behalf of their parents and the parents go to sign. When sitting down, documents here, we have to go through them and make sure whoever's signing them actually understands and accepts what's in them, and it's not just, oh well, the kid said that's what it should be, so that's what I'm agreeing to. Documents often are drafted before they're executed and sent for review. That's fine, but the testator has to be consulted with any provisions within the document and agree with their inclusions. There's been a lot of cases, as I said before, rises in elder abuse, children having documents drafted against their parents' wishes. If I've received instructions from an adult child, I will always request to meet with the parent and to ensure that that's their actual instructions. And quite often I will ask adult children to leave the room when I'm talking to parents, because you just want to make sure that they're confident that that's their instructions that you're getting and that's their intention. It's quite funny how often I meet with people and I go, oh yeah, it's fine, whatever they said's fine, and it's really not fine. It's your will and it has to do what you say. The fourth main thing are the specific proper formalities, and this relates to execution clauses and how things have to be witnessed. So when executing a will, a testator has to be in the presence of 2 witnesses. You all have to be present together throughout the entire process of the execution. There is obviously the exception in this age of COVID. Documents can be witnessed via teleconference in certain circumstances, but the requirement is that all parties must still be present at the same time. So where we're sitting here over teleconference webinars, we can witness, but we all have to be present at the same time. We can't have someone sign and then someone hand the document to the next person to witness it. That would make it invalid. The witness to will cannot be a beneficiary under the will. They also cannot be married to a beneficiary under the will, and the will has to be dated on the date of execution. This one trips a lot of people up. If a beneficiary or a spouse of a beneficiary executes a will, it can render it invalid. So that's sort of a basics of what must be contained in a will. I get a lot of questions about people, do I need to write it in a certain way? You can write your will on paper. Hell, you can write your will on a napkin. There is no issue of what it's written on, provided it's witnessed correctly and it's dated correctly. There's no particular wording requirements. Obviously, the better the drafting, the less likely it will be contested, and you want it to be really clear of your intentions and not ambiguous with who gets what. There is, and this is one that always gets raised when I sort of say it has to be written, has to be witnessed. I'm sure a lot of you have heard there was a case in Queensland, I think it was, where a court recognised a text message as a valid will. However, we do not recommend relying on this case. If you're thinking of texting your intentions, just don't do it. It's just too risky. That particular case, there were very special circumstances as to why they decided to let it be valid in the end, but we certainly do not recommend saying, hey, someone else got passed with a text message, I might do it too. Just do the document correctly and have it witnessed correctly, and we'll make sure that your wishes are upheld. How do you go about getting a will? Obviously, you can see a solicitor who specialises in estate planning. Not all solicitors specialise in estate planning, so choose your lawyer carefully. Bad drafting can lead to problems. No matter how happy a family is when they come to see me, there's always a risk that changes by the time someone passes away. There's a reason why I have a job, and that's really sad to say, but quite often people who start off happy and yep, it's all good, when someone passes away, things can change very dramatically. So the clearer your document, the better it is drafted, the more protection you'll have for your family after you pass away. I also get a lot of questions about what do I think about will kits, and I have to say for $29.90, I think they're not a bad option. As an estate lawyer, probably shouldn't be saying that, but if your assets are all held as you as a sole individual and you simply want to leave everything to one person, they're perfectly fine. They have the proper execution clauses, they're laid out very clearly, they're an entirely valid document, and I have no issue with them. However, as soon as you need to consider contingencies in your estate, it's time to get a more substantial document. The will kits just cannot cover it if you say, well, I'm going to leave it to this person, but if this happens, I need to do that. So definitely don't have anything against them, but if you have anything more complicated than a very, very basic, I have this and I leave it to that person, you really do need to get something more substantial. Costs of a will, well, that really varies firm to firm. At Griffin Legal, we charge a fixed fee for our estate planning, and depending on the type of will you have, our costs start at $4.95, including GST. Now, I know there are a lot of firms that charge a lot less than that, and I know a lot of firms who charge a lot more for the exact same thing. So the most important thing is to really shop around and find a lawyer that you're comfortable dealing with. There's no point going to a solicitor that might be cheap but is not listening to what you're saying, and you end up with something you don't want. You want to make sure your will's properly drafted and that you're comfortable with the results. The other thing to consider is how often should you be updating your will? It's really problematic. It can be actually more problematic to have an out-of-date will versus no will at all. So we recommend updating your will sort of every 3 to 5 years, or if your assets have changed substantially, such as you sell a house or a particular major asset you were leaving to someone. If one of your beneficiaries or executors passes away, that might be a time to update, or if your kids are no longer minors, you might not need some of the clauses that are in the current will, or if you get divorced, or if you get married, you should also do a new will. If your will hasn't been drafted properly, this can create problems if you haven't preempted marriage. So having your out-of-date will can be really problematic. Imagine leaving everything to one of your friends. Years later, you forget about it. You might not be friends anymore. You pass away. If you haven't redone your will since you did that original one, that will remains valid. And Therefore, everything you had may be passing to someone that you no longer even in contact with. Divorce does invalidate parts of the will that relate to your former spouse, but the rest of the document remains intact, whereas marriage invalidates an entire will unless you have a particular clause drafted in there to ensure that it can continue after your marriage. So things to think about. There's lots of little tricky things about wills that you need to make sure are in place to make sure that you've got a valid document. Next slide. Okay, what information is required for a will? Up on the slide there is a list of things if you're going to see a lawyer. They're the kind of things you need to take along with you so that they'll be able to draft the document for you. Your solicitor may also ask for some details about your assets, and that's really to ensure that they are giving you proper advice depending on how your assets are held. For example, if you have things held in a trust, a company, or property jointly held, there may be further considerations and advice required, and it may require different sort of clauses to be drafted in your will. So up there on the slide, you've got to have your executor details. You need to know who you want gifts to go to, specific or residue, which is the leftover of your estate. Your beneficiary details, including individuals and charities if you're going to include them, and who do you want everything to go to. The executor is a requirement of a will. They're the person who's going to actually take your will and administer the estate. So how do you choose a good one? You should choose someone that you trust to handle your affairs when you pass away. And it should be someone you expect to outlive you. There's no point appointing your grandma if she's going to pass away before you. And you should always include a backup executor. Even though you appoint someone who might outlive you, they may not actually want to take the task on. It's a pretty big responsibility. So not everyone does want to do it. Your executor can be a beneficiary under your will. There's a lot of misunderstanding about that. So your executor and beneficiary can be the same problem. There's no problem with that. That's very common. Or it can be a friend or another person over the age of 18. Your executor can administer the estate themselves, or they can get assistance from a lawyer to prepare documents and assist with probate if it's needed and correspondence with asset institutions. Any expenses that your executor incurs can be paid from your estate before any distributions are made. So if they're going to be out of pocket, and quite often they are, they get reimbursed before the beneficiaries obtain their gifts under the will. You can appoint joint executors, but be aware, if you appoint more than one person to act as your executor jointly, all those appointed must execute and authorise every document. This can be expensive, it can be time consuming, particularly where you've got executors living in different towns or states or even countries. A lot of parents I know are tempted to appoint all of their children in the interest of being fair. My experience is this is not always a good idea, especially if they all live in different places. It is a real administrative headache and nightmare and adds additional cost. And so I wouldn't recommend it, but as I said, it's entirely up to you. You are able to appoint whoever and however many you want. Next slide. Okay, so different forms of gifts. Gifts can be specific, such as I leave my diamond engagement ring to my son. They can be specific amounts of cash. For example, I leave $10,000 to my son, or they can be in broader terms. So I leave 10% of the value of my estate, or I leave the balance of a particular account to a certain person. The risk with specific gifts is if things change between the time of executing the will and the time of death, then the gift will fail. For example, if you leave your red car to your child and during the term of your life you sell your red car and buy a blue car, that gift will fail and the blue car will form part of the residue. It's just depending on how you word things, it can be really tricky, and gifts fail on a regular basis. Similar situations arise if you leave an amount of money to someone and your estate doesn't have that amount of money to give. I recently had an estate where they left specific gifts of money to a range of beneficiaries, totaling about $300,000. The estate was only worth about $75,000 when they died. So those specific gifts all failed. The issue that arises with these specific gifts can be avoided with good drafting, and this is where it's really beneficial to go and see an estate planning lawyer. So if a client wishes to leave a specific gift of money, we will always draft additional clauses to allow for proportions to be paid in the event the estate doesn't have enough funds to cover those gifts. This prevents the total gift fail, and it's certainly not something that's covered in a simple will kit. So people often feel very generous when they're drafting their will, but you don't know what you're going to end up with when you do finally pass away. So it's just something to have in your mind when you are making specific gifts. So when considering leaving a gift to a charity, you can leave a specific gift, or you can leave a gift of residue of your estate. So it could be left as a percentage of the residue of your estate, split between a number of beneficiaries, or charity could be entered as a backup in the event of a whole family tragedy, which we mentioned a bit earlier. As also noted earlier, some charities have specific wording for leaving gifts for specific purposes or for general use. At the end of the day, look, it's your will. You can decide how much you want to leave and whether you'd like to place any conditions on those funds for use by any charity. Next slide. So, protecting your assets. This is where I sort of mentioned earlier about testamentary trusts. They're recommended for where you have very young beneficiaries or where your beneficiary may not be able to take care of the assets on their own. Control is the key to protecting assets in a testamentary trust. As the trustee is the actual owner of the assets, the trustee is the actual owner of the assets, holding them on behalf of the beneficiaries. That means that if the beneficiaries end up in a dispute, the assets of the trust cannot be taken from them, as they actually have no entitlement to anything from the trust until such time as funds or assets are distributed to them. So when deciding who should be your trustee, it's very similar to deciding who should be the executor of your estate. You need to take into account the individual circumstances of the people you're considering. If they're at risk of bankruptcy or family disputes as a result of relationship breakdowns, don't appoint them. Or if you do want to appoint them, make sure your will's drafted to ensure that they are excluded in the event of risky situations, so they can be reinstated once any trouble's passed, but that removes the risk of any of your assets being under attack should your trustee end up in trouble themselves. A testamentary trust is a really complicated document, but it is with good reason. It's really substantial and it covers a lot of things. So you should always, if you're going to prepare a testamentary trust in your will, always get advice from an estate planning lawyer in that situation. Some of the things, extra things with testamentary trust, which I've copied up in the slide there as well, is there are additional tax benefits. Kids are not taxed as minors, so they get a greater tax-free threshold. This is not, obviously appropriate for all situations, but there are lots of situations where it may be. So you just got to look at your own circumstances, look at your assets, look at your family, and what would benefit them. The other funny thing about testamentary trusts, when people come to draft them with me, they're, oh, well, what's the benefit to me? You are drafting the will, there is no benefit to you. Including a testamentary trust in your will specifically benefits your beneficiaries. Unfortunately, you won't see any benefit of that until you will be passed away when it actually comes into effect. So next slide. So, big thing, protecting your assets. Really, you've got to properly consider your situation. So as we've sort of talked throughout the slides, property, how it's held jointly, tenants in common, individually. If you've got businesses and your certain family structures, you've got to consider guardianship of your minors, how you're going to look after them. Superannuation is a big one that plays a big role, because usually superannuation is one of the biggest assets that a person has as part of their estate. So how that's set up can really affect how your estate is run and how you should be having your documents drafted. All these things on this slide should be considered when you're deciding what kind of will you want to prepare and who you want to leave your estate to. You've got to make sure that any will that you do draft is made in accordance with any requirements of your entity structures. So this includes company constitutions and trustees that you may be involved with. Family trusts are very common these days. A lot of family-run businesses have companies, so they'll have a constitution. And within those, there's quite often specific requirements. What happens to a director or a shareholder when they pass away, or what happens to a trustee of a family, of a discretionary trust if something happens to them. Your will needs to be drafted so that it works together with these documents. There's no point drafting a will that's saying, I leave all my shares and directorship in this company to X, when the company constitution says when X dies, it actually goes over to this person. So very important. Quite often, if you do go to see a solicitor, they'll ask for copies of those documents to make sure that the drafting is done in accordance with other documents that you have that you need to adhere to, so that your elements of your will don't fail for being in conflict with your existing entity structures. So if you've got any of the situations listed on this slide, you should be considering more than a simple will kit, and you should get proper advice before preparing your will or updating your will. So that brings me to sort of the end of the overview of what a will is and things to consider. I'm happy to take any questions now.
Thanks for that, Nicole. That was really informative. I've got a couple of questions coming through. The first is, hi, Nicole, should you let your family know what is in your will? Should you share a copy with your family?
That's really a personal decision. Sometimes people draft wills and they don't want people to know because they don't want to upset people. Other people I have, when they come to make a will, they say, send me an electronic copy, I need to disperse it to the family. And look, that's entirely fine, you can do that. And quite often then that also assists if someone does pass away and trying to locate the original and things like that, people know about it. And you can actually get probate using a copy of a will if the original can't be found. However, we don't recommend it, and it's a lot more paperwork and a lot trickier to do. So there's no issue sharing it with your family. It depends on your personal family situation. If you think someone's going to look and go, oh, that's not fair, they got more, or I think I should get more, and I don't think it's fair, it's being split equally, you know, there's no requirement for you to share it with anyone. So we do recommend telling your executor, hey, do you mind being my executor? Just as a heads up, it's a good discussion to have so people know that they might be called upon, but there's no requirement for you to share or tell anybody.
Excellent, thank you. Another question is there a preferred type of bequest gift? What is the best one?
That comes down to the charity you want to leave to. As I said, you can leave specifically and you can leave specific conditions. You know, I'm leaving this gift, for example, say you're leaving it to the RSPCA, I only want my gift to be used for cats and not dogs. And the charity is actually bound by that. Otherwise, you can do just a general thing. I'm just leaving this gift for the general uses of the charity. Some people get a bit funny about that because they're worried about it being used for charities administration costs rather than for specific gifts. So that's quite often why different charities will have specific wording to say, if you want to leave it for this purpose, use this words. If you want to leave it for that purpose, leave that. If you want us to have discretion, use these words. So it all comes down to the actual charity that you are leaving to. And it depends on your estate. If you've got a large estate, you might just want to leave a percentage or a specific gift that way. An estate I had recently, this woman didn't really realise what she had. She left specific gifts to her family, individuals, and left the balance of the residue to a charity. The charity ended up with about $3 million after the family just got about $50,000 each. So it's just sort of being aware of what you've got and what you'd like to leave and what charity you're leaving to as to whether the type of bequest you should leave. And it doesn't just have to be cash, it can be assets as well. People do that quite often. A common one is to leave property to certain charities that assist with housing and things like that. That's very common. So
thank you for that. Yeah, so just as a bit of a more specific situation. So we've got another question as well. So what happens if your executor dies before you do?
This is why I always say draft with an executor and a backup. So if you have a will saying, I'd like Jimmy to be my executor and Jane is the backup if something happens to Jimmy. If Jimmy passes away, Jane steps in. Wills should also be drafted to take into account if your executor is acting and then what happens if something happens to while they're acting. Again, always put a backup in there. So if you've drafted it so that you've got an executors appointed jointly, the joint executor can continue if something happens to one. As long as you have a backup in there, it doesn't invalidate your will. Now, if you've drafted a will to leave, to say, I appoint this person an executor and you haven't got a backup in there and something happens to your executor, basically your will is still valid to an extent, but instead of an executor, a third person will have to apply to the court to be given what's known as letters of administration so that they can deal with your estate in accordance with your will, but they're not a named person in the will. So the will can still be followed, but it just requires a little bit more paperwork and an application to the court to actually say, okay, this person passed away, the executor has already passed away and is unable to act, I'll do it, I'll step up and do it, but I need to make an application to say that I can.
Great, excellent, thank you. We'll do maybe 2 or 3 more questions. So the next one is, do you have a specific format to adopt when making a will?
We do. It depends on who you see. As long as your will covers those requirements. So you've got to state who you are, who you want to be your executor, who you're leaving any gifts to, who your beneficiaries are. And it's got to be executed correctly, and it's got to be dated correctly. So absolutely, and every lawyer will have a slightly different formatting for their wills, but they all must contain those basic things in order to be valid. So if you want to see what a will standard looks like, go and have a look at one of the will drafting kits. It actually sort of lays out all the basics, and all wills sort of follow that general things. That said, I've seen some really badly drafted documents from lawyers. It's it's sort of something they're always changing, but there's certain minimum things that must be in there to make sure they're valid.
Right, okay. And if there is a badly drafted will, does it make it more difficult to then execute the will, or is it just that it's maybe not as clear as it should be?
A badly drafted will is horrendous when you get to the estate administration part. If they're unclear, it creates issues. If potential claims can arise, and that's usually where issues arise with families, when the will's unclear, or if the will is drafted such that they didn't sort of anticipate something, or they didn't anticipate a property being owned in a certain way and they've left it, so then someone feels they've missed out. It's just a really difficult thing to do, and it can create a lot of extra expense when you're applying to the court, because if you cannot determine what is actually meant by a will, you actually need to make an application to the court to make a determination. Okay, well, what did they actually mean by this clause in this will? And that's expensive and it's time consuming. So make sure it's clear as much as you can. So good drafting is really important.
Excellent. Thanks for that, Nicole. And just one more question. Can you leave shares in your will to a charity?
You can, yes. Is this a private or public company shares?
I'm not too sure. They haven't specified. It just says, can you leave shares?
You can leave shares, yes, absolutely. Quite often we contact share registries to say, there's been a gift of this in the will, and it's basically just a case of then signing over through the share registry. It's quite complicated. Share registries have a lot of paperwork to do stuff, but a share in your name that you own is your asset that does form part of your estate, and therefore it can be gifted directly rather than being sold and then money being given. So
beautiful, excellent, thank you. Might be a bit sneaky and include a few more questions if that's all right with you. We have one that is, if a de facto couple have made a will using a will kit, would this be sufficient to prevent an ex-spouse making a claim from their will, which was made when they were married?
There is nothing that will prevent an ex-spouse making a claim. So even if you have a perfectly drafted will from a lawyer, if you have an ex-spouse, they are, depending what state you're in, they are in the category of people who can make a claim on your will. So if someone's going to make a claim, they're going to make a claim. How successful they will be will depend on the circumstances. So if you have an ex-spouse, you've had a financial settlement done, there were documents done in place, we'll often draft wills to say, a declaration to say, I haven't left anything for this person because we were divorced this long ago, we came to a financial settlement, I don't want them to get anything out of my will. And the court will take that into account if a claim is made on the estate. So unfortunately, there's nothing you can do to prevent someone making a claim, but what you have written or the circumstances will determine whether or not that claim is successful. The longer it was since you've been married, the less likely a person is able to make a claim. So yeah, unfortunately, even a greatly drafted document won't prevent someone if they're going to try, but whether or not they're successful, that's another story.
Sure. Thanks for that, Nicole. And the last question for now is, what are the best place to keep your will and who to tell?
Tell your executor, 100%. We give clients the option, do they want to keep it in our safe custody? So all lawyers will have a safe that they keep documents in. You can leave it at your solicitors and then just have a copy. If you've got it at a solicitor, no doubt their name will be splashed all over the front, so that's usually the starting point if you're looking for a will. I get a lot of questions about what if I leave my will at my solicitors and they close or they merge with someone else. The Law Society of every state keeps a record of law firms transitioning, so at all stages we can track wills. I've had to track wills that have gone through 5 different lawyer changes and interstate, and we can usually find them. So as I said, if you've got a copy somewhere and you've got the original stored somewhere else, that's a really good idea. But make sure your executor, they're a good person to know, and even just give them a copy. And you can even just give them a sealed copy. I've done my will and I've left a copy with my parents and a friend. They're in a sealed envelope, and it's just like, if anything happens, someone pull this document out and it will tell you where to find everything, where the originals are kept and everything like that. So it's a good idea someone knows where to find it, but yeah, originals, certainly you can leave it stored with your solicitor, and then they're always safe there, they're fire protected, and yeah, just let someone know. If someone had a will with me, oh, my executor, go see Griffin, you'll find the will there. The other thing is, if your wills are stored with solicitors, this is going to sound really awful, but we actually all have to keep an eye on death notices. And if we see that someone has passed away, a client, we will then contact to say, hey, we have the original document to the executor. You've been named. If you want the document, come and get it, sort of thing. So, and quite often lawyers also will put notices in our the Law Society notices and things like that. Hey, someone's passed away. Does anyone have this will? So there's always ways to track it.
Great, excellent. Thank you very much for that, Nicole. And I'll pass it on to Lisa now, who will continue the rest of our presentation today.
Thanks, Nicole. I hope you all found that as insightful as I did. I guess I just wanted to take this time to give you a little background on MDFA and some of the things that we've achieved over the past 20 years. So MDFA was established in 2001 by Dr. Paul Beaumont. His vision was to develop a patient-centric, independent and trusted organisation for those living with or at risk of macular disease. We are the national peak body representing the interests of 8.5 million Australians living with or at risk of macular disease and their families. Macular disease is the leading cause of severe vision loss and blindness in Australia. There are 22 conditions that can affect the macula, the part of the retina responsible for detailed central vision. The most common conditions are age-related macular degeneration and diabetic eye disease. Our purpose is to reduce the incidence and impact of macular disease through leadership in prevention and early detection, disease management, advocacy, and research. We work collaboratively and in partnership with our community, health professionals, researchers, and government to minimise the impact of macular disease. While MDFA has access to some government funding, applying for and being a successful recipient of these funds is competitive and often difficult. As such, we rely heavily on the generosity of everyday Australians to enable us to continue to empower the macular disease community well into the future. Fundraising also allows us to support talented researchers to continue their life-changing work. Even today's webinar is made possible through the generous donations of our supporters. So put simply, without our community, we simply couldn't fulfill our purpose. MDFA is committed to reaching more Australians living with or at risk of MD to build a better understanding of macular disease and to increase awareness of risk, prevention and treatment. MDFA strives to provide accessible and timely support to the macular disease community to live optimally throughout their disease journey. We work to support our community across Australia aligned to their changing needs. As the national representative body for the macular disease community, our work is evidence-based and co-developed with our community. Together we work to influence positive policy change in health, aged care and disability systems. MDFA's translation of research helps to support our knowledge base so that we can provide better patient outcomes for those living with macular disease. Every gift is important to MDFA and can have a direct impact in so many ways. Research, so through the generous support of Australians like you, MDFA has been able to fund more than $5.1 million in research projects since 2011. Your gift can directly support future research of world-leading Australian researchers who aim to reduce the impact of macular disease and ultimately find a cure. Prevention and early detection. With 8.5 million at risk of macular disease, your gift can help reach those at risk through education and campaigns as early detection saves sight. Prevention and early detection. With supports and services, Living with macular disease can be very challenging, and your gift can help us continue to deliver individual support to thousands of Australians and reduce the risk of progressive vision loss. And advocacy. MDFA works to ensure all Australians can access treatment and resources to help them live with macular disease. Your gift can help us raise the united voice of the growing macular disease community to make lasting change for better and fairer access to government support and affordable treatment. In 20 years, your generosity has changed the lives of many. Together, we have achieved world-class outcomes. In 2011, MDFA's advocacy helped introduce affordable anti-VEGF therapy to Australians living with wet AMD. Over the past 10 years, MDFA's research grants program has invested $4.1 million in 18 world-leading Australian researchers, and we're committing another $1 million this week as part of the anniversary celebrations. Over the past 2 decades, we have delivered health education to more than 100,000 people through 2,200 seminars across Australia, handled 175,000 calls on our national helpline, and distributed almost 7 million publications. We have made over 420 submissions to government advocating on behalf of the macular disease community. Our awareness campaigns have raised awareness of AMD from 1 in 3 Australians to 2 in 3 Australians, resulting in more early detection and sight-saving intervention. And in 2018, we worked with the federal government to launch the National Strategic Action Plan for Macular Disease, which will now pave the way for the next 20 years of impact for our community. All of these achievements simply couldn't have been achieved without the support of our amazing community. We understand that it may not be possible for you to donate today, but for those of you who are thinking longer term and wanting to leave a lasting legacy, a bequest is a great way to do this. Your gift has the power to change the future for people living with macular disease in Australia. It allows you to support a cause that is important to you, potentially giving future generations the gift of sight. A bequest to MDFA is a meaningful way to make a lasting impact on the eye health and the lives of future generations. Every bequest received by MDFA allows us a considerable degree of flexibility and security in planning for the future, so we can continue to support our community and talented researchers. Of course, we know that family members and loved ones comes first, and so we encourage you to discuss your decision to leave a gift in your will with them before you proceed. A gift in your will can help you to be a part of our research and support services. With an aging population and increasing prevalence of macular disease, your support will help change the lives for generations to come. So if you want any more information on how you can support MDFA or potentially leaving a gift in your will, please visit our website. It's on the screen right now. So it's www.mdfoundation.com.au. And you can contact our team for further information as well, or that can be found on our website too. So I guess on behalf of Nicole and myself, I just want to take the opportunity again to say thank you so much for joining us today. We hope that you got out of today what you imagined that you would, and yeah, we look forward to talking to you more in the future and hopefully helping you through this process.